case, what did you do, what did the landlord do, and details like that. So I'm going to try to give you sort of the bird's eye view of the law of as it comes to tenants and landlords in Alberta. And if you have any further questions to discuss your particular issue, if your question would require a very short answer from me, I can deal with it right after my slides. But again, you have to understand that I cannot everything will be heard by everybody here. So there's no confidentiality. So any information that you share would become part of this public session. For anything further, you would need to consult a lawyer. You can contact our organization, Edmonton Community Legal Center, and I'll have the information at the end, the contact information at the end of the slides. Or if you speak to a lawyer, then hopefully the content from today's presentation will give you enough understanding of what your rights are, what your obligations are, so that you're better prepared to speak to a lawyer and to ask specific questions. So with that, we are looking at the main source of law. In Alberta, the relationships between landlords and tenants are governed by the Residential Tenancies Act. This is just the name of the law. Generally, main pieces of legislation in Canada are called acts, which would be a little bit misleading because we understand the word act as an action or like a performance or, you know, dance, singing act. But when we speak about law, act means a main piece of legislation that is written down, that was passed by the parliament, and it concerns a specific topic or like a specific subject. So we have like a Human Rights Act, Environmental Protection Act, Immigration Act, Divorce Act, Marriage Act. So all of those acts are basically, yeah, like written down sources of law. I also have the link at the bottom of the slide, which you can take down, write it down, or take a photo of it with your smartphones. So this link is to a website by the government of Alberta that pares down the act and explains in plain language what is it that the law says about different sides of the relationship between landlords and tenants. So it is very important to understand that the law, when it comes to landlords and tenants, so the act, governs certain kinds of living arrangements, but not all of them. So the list on the slide will show you where the act for the landlords and tenants does not apply. So there would be different rights, different rules, different obligations. So for example, if somebody lives in a mobile home, like in a big sort of like area where there are trailers and yeah, so homes that are on wheels, so to speak. So then if you go there with your trailer and then you just pay for a spot in that area, and so then your landlord is somebody who is not letting you live in their house or in their apartment building, but on that land. So that's going to be a different kind of law. Also, the same if you live in a house or an apartment where the landlord lives too. So you're just paying them rent and you share the same living spaces. Some of them like kitchen, maybe living room, dining area, storage, things like that. You might still have your own bedrooms. So then the law between the landlord and the tenant does not apply either. So you would have to look at a different legislation or a different set of laws. Also, if somebody lives in a social care facility, in a facility run and maintained by a hospital, in a nursing home, in a jail, there could be also tenants in a jail. So then there are different kinds of legislation which would have their own specific rules. So whenever you talk about an issue that you may have between the landlord and a tenant, you speak to a lawyer, or you go to the court to get help with paperwork. It is very important to mention what kind of a living arrangement it is and whether you are living with a landlord or not, because that would immediately signal to the person who gives you information and advice what kind of recourse you might have, what kind of options, and which type of law would apply. So for example, if you live in a house and the landlord lives in the same house, so then we cannot look for guidance for direction into the Residential Tenancies Act, but then your relationship with the landlord would be treated simply as a contract, and the contract law is a separate area of law. And so the person advising you, like a lawyer, would know how to proceed from that point, but they would just need to know where to look for answers and how to determine your rights. So at the very least, always tell like whoever you're speaking to about your issue, like where the landlord lives and what kind of arrangement it is that you are in, like a house, a mobile home, an apartment building.
And can I ask you a question here? I'm sorry. Regarding the landlord, if I rent the basement suite from the landlord, leaves the top or the main floor, and I rented the basement, is that gonna apply the law?
Yeah, that's a very good question. So it really depends on what kind of division of space there is. If you have a completely self-contained unit, so like you have your own entrance, you have your own kitchen there in the basement, and you have no reason to come upstairs at all, and the same for the landlord, so then you are under the act, so you will be treated just as you are living like in a separate house or in a separate apartment. So yeah, if there is no sharing of living space, like I said, you know, like if you don't share the kitchen, you don't share the laundry room, you don't share the living room with the landlord, where you know you live under the same roof, but you come and go on your own, and there might be days, weeks when you don't see each other at all. So then you would be under the act, and so that law would apply. But you know, if your daily activities overlap and you might be kind of in the same kitchen or you know in the same living room watching TV at the end of the day, so then the act does not apply, and it would be like a different kind of law, just like a contract between you and the landlord. It is a fairly common arrangement, but it's also very common that you rent like a basement suite, and then yeah, you have your completely separate life, and you barely, like you never see the landlord, and you have your privacy in your individual space there. So the relationship between the tenant and the landlord, it is still a contract under the Act. This contract is called a lease. Sometimes it can also be called an agreement. These words are interchangeable. It could be written or could be verbal. But generally, as a lawyer, I would advise you with any kinds of legal, formal business dealings that you have with anybody at all in your life, try to confine it to writing, to set out all the fundamental terms, like the dates, the money involved, when the payments have to be made, what's included, what's not included, and have both parties sign it and date it and have copies. If you cannot do like a formal document, at the very least exchange emails or text messages. It's extremely, extremely important to have it in writing, and very, very helpful if a legal problem develops in the future, because then you can always go back to your written agreement and you can show it to the other person to say that, well, you know, these are the dates when I said I would be staying in this place, or this is the amount of rent, you cannot charge me more now. Or, you know, the lease said that there was, that animals were allowed, and now, you know, you're telling me there are no animals. So anything like that, it's much easier to resolve if both parties can go back to something that was recorded, that is kind of like permanent there, and it is not as vulnerable as human memory. Because even if you think that you remember something correctly and accurately, if the other person tells you, well, no, this is not what we agreed on, if you don't have anything in writing, it's very hard to resolve the issue if you're just relying on your memory and the other person remembers differently. The lease between the landlord and the tenant cannot bypass, cannot exclude the protections under the Residential Tenancies Act. So which means that, you know, whatever rights you have as a tenant under the legislation, the landlord cannot push you out of those rights. And even if that is included in the lease and you had to go to the court or a dispute resolution service later on, the landlord cannot rely on the agreement, on the lease, which contradicts the act. So for example, under the act, the rent can only be increased once a year. So even if your contract says that the rent may be increased by the landlord 6 months later, 9 months later, and even if you sign it, the landlord cannot enforce it against you, because in the act, in the written law, it says only once a year. The same with the amount of security deposit. The security deposit cannot be higher than the monthly rent. If the landlord says in their lease that, you know, it's by a couple of $100 higher, and even if you sign it, the landlord cannot demand that you pay more, because again, it's against the minimum right for the amount of the damage deposit that we have in the act. So once the agreement is signed, the landlord, well, usually it's landlords have two copies at the same time, but if it's not happening, then they have to give you a copy of the agreement within 3 weeks. And if not, then you can stop paying rent until they deliver the copy of the signed lease. There are two types of tenancies, fixed term, which is what we commonly know as a lease, like a 1-year lease, a 2-year lease, a 6-month lease. So it starts on a specific day and ends on a specific day, so everybody knows the start, the end, and so there's no continuation expected. Although, of course, it can be continued, but then a new lease would have to be concluded. And then there's a periodic tenancy. This is the second type, that has a start date, and then it just continues on a monthly, weekly, yearly basis, sort of like as a rolling lease. A monthly lease is very common. So you might agree that, okay, like I'm renting this space for you for a month, and then I'll just continue renting from month to month, and until I tell you no, like I'll stop, or until the landlord tells you stop. With a month's notice, then you just know that it's renewed automatically without having to sign anything every month. So when it comes to legal relationship, each party has rights and obligations. Let's talk about the landlord's obligations first. So what they have to do under the law to provide you with a living space to, like, you know, that you would call your home. So they have to make the property available on the move-in date. Sometimes could be earlier if they have like space vacant and cleaned and emptied to the previous tenant already, but it has to be on the move-in date, cannot be later. The landlord must give you exclusive possession of the premises, so that, which means that they cannot enter, their agents, their workers cannot enter unless they give you a notice. So even though they own the place while you are renting from them, without notice, they cannot show up there. There are some exceptions for emergency situations that I will talk about briefly, but otherwise they have to leave you alone, and they have to let you kind of live there, conduct your life. In law, it is called peaceful enjoyment of the property. Enjoyment may be a little bit deceptive as a term. Like, enjoyment does not mean that you are celebrating every day or you're having parties there. It just means that you are entitled to a clean, comfortable place that is free of excessive noises, disturbances, and you can live there and call this place your home, even though you don't own it and you pay to somebody who owns it. The landlord also has to make sure that the property meets at least minimum health standards, and we have a separate legislation for that, Public Health Act and regulations. So these minimum health standards include conditions such as moisture levels, temperature, the sealing of windows, doors, roof, absence of toxic substances, toxic noises, absence of like bed bugs and mice and infestation, nuisances, things like that. So again, those would be minimum conditions which in Alberta, like every landlord has to provide. And if something happens to violate those conditions, they have to take steps to repair them. So let's go further into the landlord's obligations. So the landlord must give you information in writing. It could be a separate piece of paper called Notice of Landlord, or it could be included right into the lease which you are signing. So this notice says who the landlord is, the name. There might be a couple of people named there, like the landlord and their agent, or it could be the landlord and the property manager, like the owner and the property manager, like residential manager, and their contact information. There has to be an inspection conducted, ideally, of the premises when the tenant moves in and when the tenants move out. And there's an inspection report, like a written document in 3 copies, that marks each space and important fixtures and conditions in that space, you know, like bedroom 1, bedroom 2, living room, kitchen, and then kind of like the different lines on that report in terms of windows, window screens, bathroom, mirror, carpets. And so ideally the tenant should walk thoroughly through the place before they move in with the landlord. And so they look at this report and the landlord marks any deficiencies, any problems, any maybe not so perfect conditions of repairs on that report. And this report has to be, so a copy has to be given to the tenant. The tenant has to keep it for the duration of their lease, and when they move out, there has to be a move out inspection report so that both the landlord and the tenant see if there is anything new, any new problems that emerged compared to what was there when the tenant first moved in. Now let's talk about tenants' obligations. Like I said, the tenants have rights, landlords have rights, but also both parties have obligations. So the tenant is obligated to pay the rent on time. So if you remember, a couple of slides ago, I told you that if the copy of the contract is not delivered to the tenant within 3 weeks, then they can stop paying rent. But otherwise, there are no exceptions. The tenant has to pay rent. Even though there are deficiencies in the place, if there is a deterioration of the relationship, if the tenant leaves earlier then the lease would allow them. Generally, under the law, the tenant is still responsible for all the rent. And if they want to reduce the rent, or if they want to get out of the lease, they have to work with the landlord. They have to find a solution, and they have to request a reduction on the rent, for example, if the landlord is not doing something to maintain the property properly. But otherwise, the tenant cannot just decide themselves that, for example, well, I moved in November, there was no heat in my place until December, so I'm just not going to pay rent because the landlord was not doing anything. You cannot decide it on your own. If you decide it on your own, then there is a legal problem, because then you're violating your obligation to pay rent. And so then in situations where there are other tenants, so that all tenants are entitled to their peaceful enjoyment of the premises, yeah, especially when it comes to apartment buildings where you know, you have your quiet, peaceful, clean space, and so should other tenants have as well. So then you are prohibited from doing anything that would interfere with their enjoyment. So that means that you cannot have certain levels of noise at all, or after certain hours of the day, you can't be disruptive. Like for example, when you move furniture or any items, you can't be holding the doors and preventing people from getting in and out easily, like those that live there. So activities like that always have to be conducted with the keeping in mind that yes, you have your place, but if it is like a shared situation, a number of units in that building, then you have equal rights compared to others to quiet, peaceful and clean space. The tenant is also obligated to keep the premises in a reasonably clean condition. Reasonably clean means that it's not that you have to clean, you know, like mop the floors and vacuum clean and dust every day or every weekend, but it just has to be in such condition where there is no, where it does not become a health hazard and where it does not become a disturbance to other people in the building. So for example, if you don't clean or don't wash dishes and let leftover food accumulate and then it starts rotting and the smells start emanating that can be seeping out of your apartment into others, so then that's problematic. So then you're violating your obligation for keeping the place reasonably clean. The tenants are also obligated to avoid damage to the property, excluding regular wear and tear. And I'll talk about wear and tear more, and I anticipate there could be questions about wear and tear, but that essentially means anything that is outside of just using the appliances, using your home. So any other deterioration could be a violation of your obligation as a tenant. You know, obviously, certain places will deteriorate with certain objects will deteriorate with time. You know, like you use the stove, you use the fridge. You know, they may have been brand new when you moved in, but then 2 years later, they look kind of, you know, worn and used and beaten up, and they cannot be cleaned and made like shiny and sparkly, brand new looking. So that would be normal tear, wear and tear. But let's say if you break windows or you break the doors or pour water on the floor, spill water and don't mop it up, and then the floor rots or the carpets rot, and there is a big deterioration there. That's not normal wear and tear. That's just not something that happens as a result of you using this the place daily. So then this is something for which the landlord can make you responsible and can make you pay for those repairs and restorations. And is obligated to leave at the end of the tenancy. If they want to renew the lease, then they have to negotiate with the landlord. If it is a periodic tenancy, not a fixed term, so then the tenant would have to let the landlord ahead of time that I'm going to stay for another month. But otherwise, if it is a lease, let's say if the lease says that you have to move out by November 30th, that's it. You have to be gone by the end of November 30th. Now let's talk about inspection reports. So like I said, it is a really good idea to make it happen, if the landlord is not treating it as an important activity, try to follow up with the landlord and ask them to find the time to meet with you. You yourself find the time, meet with them, go through the property carefully and mark down everything that is not there looking like in a regular state of repairs. If anything if there's anything that the landlord would say that, okay, well, you know, like let's say like screens on the windows there maybe not fully functioning, but the landlord says, well, I'm going to fix it. So try to get it fixated in writing, that added to the lease, that the landlord is obligated, the landlord is promising to fix like the screens, or to provide like a new appliance within, let's say, 2 or 3 months after the person moves in. Again, whatever you expect from the landlord, whatever the landlord agrees on, it's better to confine it to writing. The landlord can do an inspection without you, but I guess ideally you have to be there, because whatever is not marked, if you're not there, you don't know what would have been missed. So it's better when 2 of you are looking at the same premise, you are there together, you can discuss any deficiencies, and both of you see exactly what is being marked and what kind of comments the landlord is making on the inspection report. The landlord is obligated to give you 2 different possible times to meet to complete the inspection report before you move in. So they would be during the day, cannot be on holidays. So with those 2 options, you have to make the time to attend one of those dates. If the inspection report is not done, then the landlord cannot simply deduct any money from your security deposit for any damage to the property. And the rationale for that is, it's hard to know what is your damage and what was already existing damage if you don't know, if it is not notated in writing from the outset, what kind of deficiencies, what kind of problems there were with the place. Sometimes landlords still deduct money without the inspection report, so then you may have a strong claim for the return of your full security deposit. If you go to the landlord-tenant resolution service, it's a court-like tribunal where legal conflicts between tenants and landlords are handled. Or sometimes you can even write to the landlord first when you receive it, and when you know that something is being deducted from your damaged deposit, and you can tell them, well, the law is that you cannot do that, you can deduct for these damages to the place because you never completed the inspection report with me. Now let's address security deposits. So as I said in the beginning, so the maximum amount on the security deposit is 1 month rent. It cannot be more, but sometimes it could be less. It cannot be increased during the tenancy as either fixed or a periodic. So the landlords have to keep the deposits in a trust-bearing account. And by law, in theory, they have to pay you interest on your security deposit, but in the last several years, the interest on security deposit accounts in Alberta have been 0. So that's why you're not receiving any interest on your security deposit accounts, because there's just nothing there being earned. The interest formally has been 0 for at least several years. So the security deposit and the statement of account must be provided to you not later than 10 days after the move out. The statement of account is a letter or like a 1-page or whatever multi-page document stating what kind of deductions were made from the security deposit. So if there were any damages, so that would have to be noted, and the landlord would say how much is deducted. If there was money outstanding for rent, so the landlord would note that as well. Any other deductions that could be there provided by the lease. And so then you would have the resulting amount with the landlord's check. If you want to dispute those deductions, again, you can go to the landlord and tenant resolution service, or depending what the deductions are, sometimes it is very simple and very straightforward. So you can start your dispute by providing a written statement to the landlord that you're intending to dispute it, because what they're deducting for is not proper. And a very immediate example, like I pointed out before, would be if they are deducting for any damage to the property, but there was never an inspection report completed. Yes?
Yes, I mean, how about depreciation? If I live in that house or apartment for about 5 years, 5 to 8 years, and then and they never paint the unit, and they didn't do anything. By the time I decided to move out, to downsize or to look for a bigger space, and they charge me, because I've been living there for a while. So how do they keep account to that?
They charge you for what?
I mean, because I lived there for a long time, because the wall is the floor or the paint, something like that. They charge me, oh, the walls are not painted, bro. There is, I mean, scratch. There is something. But I've been living there for 8 years.
Well, so if so, they charge you because they are repainting the walls. So again, if you did not do any damage to the walls, and like scratches, like minor stains, that would be normal wear and tear. They cannot charge you for that. Painting the walls, like to make them look, like fresh and basically like a new paint on the walls, that would be an upgrade to the property. So the landlord is not supposed to charge you for that either. But let's say, if you threw something against the wall, like you had a party and then, like people were playing or whatever, fooling around, threw something, there is a dent in the wall, or you smoked, or somebody inside your place, and then you kind of left burn marks on the wall. So that would be not normal wear and tear. So for that, the landlord can charge you. But things that can just happen because you are in that space every day, multiple hours, and you live there for many years. So for those kinds of deteriorations, the landlord is not supposed to charge you. But if the landlord decides to change the locks at the end of the tenancy, they can do it for safety, security reasons, to make sure that previous tenants don't have access to the suite anymore at all. So they can do it, but they cannot charge you for that. They are not supposed to charge you for carpet cleaning at the end of the tenancy, unless the carpet is unusually dirty. But again, normal wear and tear would apply to the carpet, because you walk around in that space, right? And all your family members walk around on your carpet. You don't just kind of fly in the air when you are in your apartment or in your house. So carpets do wear out, and minor stains happen just because feet step on that carpet every day continuously. So those, if the landlord wants to have the carpets cleaned professionally after that, they can, but they're not supposed to charge you. Only if the carpet is unusually dirty, like if you spilled like tomato sauce and you never cleaned it up, and so then after a while you cannot get the color off, and maybe you cannot get the smell off, and that whole patch of carpeting needs to be replaced, or you spilled water or anything like liquid, never took care to dry it out properly and immediately. So that would be beyond wear and tear, beyond normal everyday usage, and to deal with that problem, the landlord can charge you.
Okay, and okay, in Somali, do you have any question on this item? سؤال ما كقبتان ماشان أو security deposit كي واحد.
أنا قاعد سؤال كقبة.
Okay, go ahead.
marka Soomaali ahaan aan ku weydiinaya
Soomaali ahaan ii weydi.
marka aniga waxaan deganahay guriga aan deganahay 4 sano ku dhawaad
4 years.
iyada haa marka darbigana la igama rinjeynin kaarbadna la igama bedelin markii aan iri kaarbadkan markii horena waxay ii ballan qaadeen aan degayay sanad kadib inay ii bedeli doonaan markii hadda aan u sheegayna waxay ugu dhaheen ma bedelayno maxaan yeelay waxaan dhignay 2016 markaan iri darbiga maad iga rinjiyeysana waxay ugu dhaheen agreement adigoo saxiixin waxba kaama rinjiyeynino marka maxay noqonaysaa tilaabada aan qaadi karo
agreementiga maxaa waay laakiin what kind of agreement
guryaha soo marka la degaya agreement lama saxiixo
liiska cusub haa
liiska cusub liiska 3 sano oo la soo dhaafay waan saxiixayay laakiin sanadkan ma aanan saxiixin marka waxay ugu xujeeyeen inaa liiska aan cusboonaysiiyo si ay waxa iigu qabtaan waxa aan u baahanahay marka ma noqon kartaa shardi ay ugu xiri karaan maxayse noqon kartaa tilaabada aan aniga xaggayga aan mudanahay
and the lady is saying that she has been living in a premises for about 4 years. And by the time she was moving in, they say, oh, we painted the wall after a while, you know, and then we clean or we changed the carpet. But after 3 years, they didn't do anything, and she decided not to sign another lease agreement because she's looking for a better or maybe affordable. And now they are saying when she asked it, oh, the carpet is dirty. Why don't you say, oh, you have to sign a lease. You have to sign that you are going to live in here. Is that allowable or?
Sorry, like what? Like they are forcing her to sign a lease?
No, because yes, they're forcing her in order them to do the carpet to change. She has to agree on signing a new lease.
Okay, well, so the landlord would have to be, the landlord has to maintain the premises in a state of a good repair. So if there is something wrong with those carpets already, then the landlord has to do it during the tenancy.
But they take advantage of the, you know, some landlords, they take advantage on some people.
Well, so like what I'm saying is that the landlord is not obligated to replace the carpets if there is not, you know, if the carpets, like if they are old, but there's, you know, like they're in a good condition, there are no holes in those carpets, they don't smell, there is no like dirt stuck in those carpets. If there's no visible kind of like ugly hook to them, if that's not the case, then the landlord is not obligated to do it. And so then they can tell the tenant that you have to sign a new lease. Like there is nothing precluding them. You know, that might not be like a friendly and kind thing to do, but you can't have a legal issue against the landlord if they refuse to replace the carpet. If there is, again, like I said, you know, if there is nothing like really seriously wrong with those carpets.
Okay.
And then they just offered you that, well, you know, if we renew the tenancy for a long term, we will replace the carpets. And there is nothing in the law to
lagu noolaan karin inay bedelaan laakiin waxay rabaan inaad saxiixdid because waxay rabaan in lacagtaada ay sii cunaan another year. So that is like kolkaa ka guurto waa laga yaabaa inay guriga qofka kale ay ka bedelaan.
waa run waaba policy-gooda inay marka laga qofka cusubna soo dhaweeyaan qofka horeetana ay
waa caadadooda waaye. laakiin meeshaan aanan looyradu waxay dhahday waxa waaye kolka guriga aad u guuraysiin liiska waxa waaye inspectionka koowaad, the first inspectionka, what they call move inka, waxa waaye inaad koobi aad ka haysataan waaye. haddana move outka iyo move inka la isku fiirinaya. haye su-aalka joogka kale yaa qaba gabdhaha kale ama wiilasha kale. Okay, no other question. Okay.
Yeah, okay, thank you very much, Aliyah. So let's talk about rent increases then. So rent increase so remember, so if you are in a fixed tenancy, so starting on a whatever date, finishing 6 months later or a year later, rent cannot absolutely be increased during that time. But if it is a periodic tenancy from month to month, it can be increased, but the notice has to be given by the landlord in writing. It has to be signed. It has to say when the new rent amount would take effect. And the rent can only be increased if the person has lived in the place for at least a year, or if the person lives in the place for more than a year, they just, you know, kind of roll from month to month. So for a couple of years, so let's say they increased it once in 2020 in October, they cannot do it again in March 2021. 12 months has to pass. There's no restriction on the amount of the rent increase. So some provinces have that, but in Alberta, the landlord can charge as much as they want. But again, in a periodic tenancy, they can only do it with each individual tenant or a family only once in 12 months. Subletting can be possible when the landlord, or when the tenant who is officially on the lease, they can find somebody else to live in this space for a couple of months, could be even like for maybe half a year, for a year, to help the tenant with the rent. So that can be done, but the landlord has to allow it, or the landlord cannot refuse unless they have reasonable grounds to refuse. So for example, if you tell the landlord that, well, this person is going to be subletting for me, I'm going to be away, like I'm going to travel or maybe like work outside of Alberta for a couple of months. And so the landlord asks about the person's employment situation. It turns out that the person is not employed. Well, then the landlord could be concerned, well, how is this person going to pay the rent? So it's kind of not reliable, and they don't want to deal with a problem like that, where somebody living there not paying rent. So that would be a reasonable ground to refuse. But otherwise, the landlord cannot say no and not give you any reason, and they just don't want to deal with a sublet because, you know, it just a little bit maybe extra effort for them to be mindful that you have let somebody else into the space. So their refusal has to be justified sort of by common sense, by reason. They cannot charge, the landlord cannot charge a fee to give a permission to a sublet. And if you ask the landlord in writing to let somebody else live in your space and 2 weeks pass and the landlord does not respond, you can assume that the landlord agreed. And so then you can just let the person go in and, you know, have your own agreement with the person to whom you are subletting. It is really recommended that you, hello?
Kala wax yar iga qaldamay please. Wax badan ma wax yar.
So is somebody asking a question? Hello? Okay, I just heard somebody talking, so please remember to mute your mic if you're not asking a question of me, so that I know to carry on with the presentation. If you want to talk to each other, please use the chat box, but don't unmute yourselves, because again, we have a large group, and the idea is that people listen to me present and then I ask and answer questions, and anything else outside of that, so let's just not use the time of the presentation for any other kinds of exchanges. Remember how I told you that landlords have to give you exclusive possession of the premises for the duration of your lease, and they have to give you notice if they want to enter, if any workers have to enter. So that's a very solid rule. If they want to come in to make repairs, inspect the premises to see if any repairs could be needed in the future, if the property is going to be sold down the road, they want to show it to prospective buyers. So the landlord can do that, like it's their property after all, they own it. But again, because you have the exclusive possession for the duration of your lease, they have to give you notice, 24 hours. They don't have to give it to you hand it in person when you are there. What happens in the reality is that landlord would just slip the notice under your door, and would tell, and the notice would just say that the landlord would enter the premises, next day between 6 and 8 p.m. for whatever purpose, or somebody on behalf of the landlord would do it. Okay, so I think we have a question from Nazra. So Nazra is trying to keep the Nazra, please go ahead.
Okay, I have one question. You stay in an apartment a year, and then after the year finish, the landlord doesn't give you any paper or any document that you say renewal, and then the next month he charge you extra money. What are you gonna do about it?
Well, did you it always depends, like a legal answer to a question is often it depends. So what kind of charges were they, for what?
For the extra, for the year when you finish, you pay the rent as the first agreement for the first like lease agreement, and then after finish 1 year, the first month for the new renewal, you didn't renew because he didn't tell you anything, and then he charged you extra money for the he changed you as a 1 month to month amount, and you didn't agree with, and you want to stay that place another year. So how you gonna do?
So if you did not agree to stay, if you did not agree, why did you stay? Why did you not leave at the end of your lease?
No, you stay. You want to stay there. You don't want to move, and then. He didn't tell you that you will come and renew. No, any letter say that come and renew, and then they charge you extra money. When you see your account is already cut off like $150. And
well, but did you tell the landlord that you are going to be staying for another year?
When you speak with the manager, then the manager says, okay, don't worry, bring the money with the money order. And then,
so the money for what?
For the rent, for the next month rent.
Well, what did you agree on at the end of your lease? What did you agree on, that you're going to have to be there for 12 months or just for a month?
No, the end of the lease agreement is done for 12 months. If it's finished, I'm supposed to renew another one, right?
Well, so you're not supposed to do anything. It's whatever you agree on. So whatever is the agreement between you and the landlord, there's no hard weight and stone rule.
You didn't see anyone? No one came to you and asked you come and renew or any document in your house that says you come and renew, but they only deduct the money, and then you don't know what you're gonna do about it.
So I'm still not understanding. Well, did you agree? Did you tell to the landlord that you're going to stay for another 12 months? Did that happen?
After they cut the...
Hello? Okay, I don't know, I stopped hearing an address, so that might be a technical issue, but in the interest of time, so I'll just make my best understanding of the situation. So you have to agree, landlord, if you want to stay for another for a month-to-month tenancy, so that you have to agree with the landlord before your lease would expire, that next month is going to be month to month.
Are you gonna?
You can't just continue staying there. You can't continue staying there without getting into agreement with the landlord, because your lease, let's say, if lease is up by September 30th, you have to leave. If you don't leave from October 30th So then you are, if there is no new lease signed, so then the landlord can charge you for the amount of time that you actually stay in the place. But for your protection, you need to speak to the landlord ahead of time and say that, okay, like my lease is expired. Let's say if your lease is expired on October 30th, talk to your landlord on October 20th. And you tell them that I am going to stay you the lease for the next 6 months. If you did not do that, and if you stayed in the place continuously, so the landlord would charge you for that extra month if you stayed there.
Okay, there's a problem here. You know, in our community, some of them are not educated, and they didn't even, when they get a letter, so it's impossible to read the letter. And then maybe if you and then you just stay at home, and then they cut everybody the money, and then after 6 months they charge you like 600 and 400, something like that. What are you gonna do? Are you gonna pay that money, or?
Well, I don't know what the charges are for, so you know I cannot comment on that. You're not giving me enough information. But generally, you know, in Canada, everybody is presumed to know the law. If you are not educated, if you don't understand English, you have to find somebody who can explain it to you. You know, as adults, we are all presumed to know the law, and no knowledge of the law is no excuse to not perform your obligations. So if somebody has difficulty with the language, or like with the written language, and they get a notice, like, you know, if they see that landlord is coming to them and they hand out a piece of paper, the person should understand that's something important. You know, I'd better find out what it is. You know, this is not like a flyer slipped under your door with, you know, advertising whatever goods that you might not want. But from the situation, the person should understand that, like, this is something important. I need to take steps to make effort to find out what is it that this letter says. If they don't do that, then they cannot get out of their responsibility by saying, well, I did not understand what it said. When you're an adult, you have to take steps to find out. Yeah, but you didn't. It happens to me when I was moving out, and I talked to the manager. I give him a notice of a month notice. And when I give him the month notice, and he says, okay, this is, he just noticed later, because when I give him twice a notice. I write for him a message, I call him, and I call him again to tell him that I'm moving out. Then after 1 week, my moving out comes, the guy says, oh, I'm so sorry, I didn't tell them, my landlord, the landlord. So you just cut off your money from the account and tell your bank that to stop the payment. Well, do you have proof that you gave notice? Yeah, and then what proof do you have that you did give notice? If the landlord says that, well, we never received your notice, how can you prove it? The manager knows, but the main office, they don't know anything because he didn't inform them that I'm moving out. Well, so far as you have the proof that you gave the notice, then you gave proper notice. If they are withholding your security deposit, you can make a claim against them. Okay. Let me tell you what the notice amount has to be. Okay. Since we are on this subject. So obviously with a fixed term tenancy, you don't have to give notice. You know, if your lease says you have to be out by September 30th, you are out, and you don't need to tell the landlord ahead of time. But if it is a periodic tenancy, let's say if you just stay in the place and you're considered to be there only just for a month, so then your notice has to be given on the first day of your period. So on the first day of the month to be effective the last day. So for example, if you're on a month-to-month lease, and let's say you want to move out by the end of October, by the end of this month. Yeah. Well, now it's too late because you should have given your notice on the 1st of October to leave by the end of October. So now it would be too late. And so if you do move out, okay, so somebody please don't interrupt me when I'm speaking. It's very hard to make sure that everybody else understands. So if you have a question, raise your hand, drop your question in the chat box. But You know, I cannot see you also. I don't know who wants to say whatever, but don't just interrupt me, because then like whatever I'm trying to say might not be understood by everybody else. So yeah, so they on a month-to-month tenancy, the notice has to be at least 30 days on the first day of the month. So like I said, to move out at the end of October of this month, your notice should have been given to the landlord on the first of the month. So if you did not do it, then you um, for rent for November. Landlord's email or phone number, email them, like let's say you handed in your notice in person, email them or text them on the same date or like whenever the date is, but to confirm, tell them that I gave my notice to the property manager on September 1st or anything like that, because then that's the easiest way to prove that you did give your notice properly. Yeah, so email or phone number, like if it is a cell phone number, then a text message, because then if there is a legal problem, you can make a good strong claim and you're likely to succeed if you can prove that you did give the notice. Otherwise, let's say if you're in a situation where you did give a notice but you did not have a copy of that notice yourself, and you say, well, I did give it to the property manager, let's say the property manager says, no, I never received anything from you. If you have nothing else, then it's he said, she said. And if you take it to the court, then you are at the mercy of the judge or at the mercy of the decision maker who is adjudicating your complaint, who they believe more, if they believe you or the property manager. So with that, so we talked about ending the fixed term tenancy. Okay, so I just wanted to tell you a few more details about entry of the premises. So the landlord has to give notice if they want to enter. In some situations, they can enter without giving you a 24-hour notice and they don't need your consent if there's an emergency. Yeah, like for example, if you're not at home and for some reason the water starts bursting from your taps, so something needs to be done like right away, or there is like maybe a fire hazard and the alarms are going off, and so they can't wait for 24 hours, of course, to intervene and do whatever repairs are needed. And also if they believe that you have abandoned the property, let's say nobody has seen you for a couple of weeks, like mail is piling up uncollected, maybe, you know, like food was left behind and it starts rotting and then it kind of smells from the entrance door. So then for days, for weeks, so then the landlord can conclude, and it's within their right to conclude that, well, looks like everybody's gone, so I need to know what's happening inside of that place, because I need to know if any repairs are to be done or if I need to re-rent the place. So then they can go ahead and enter the house or the apartment. As a tenant, you cannot change the locks without the landlord's consent. As a tenant, you can install the lock that only locks the door when someone is inside. The landlord, of course, the landlord does not have control, does not have restrictions on what kind of locks they want to install. But if they want to change the locks and you are still living there under your agreement, so they come in, they change the locks, they have to give you the new key immediately, because you should never be in a situation where the lock has been changed and you don't have the key and you are afraid to leave. because you don't know how you're going to come back, or you were not in the place and now you're locked out and you're waiting for the landlord to come. So that would be a violation of the landlord's responsibility. They have to make sure to give you the key right away. So practically speaking, so they have to contact you and arrange for a time when you are there. They come in, you know, it doesn't take very long to change locks, so they come in, you're there. You wait for them to finish the job, they give you the key, they leave, and so then the issue is dealt with. Okay, so we talked about ending a periodic tenancy. So again, remember, periodic tenancy ending, you have to give your notice on the first day of the month in which you want to leave. So want to leave by, and usually if it is a month-to-month tenancy, so then your tenancy starts on the first day of the month, ends on the last. So if you want to leave at the end of that month, by midnight on the first day of that month, your notice, your written notice, has to be communicated to the landlord or the property manager, the residential on-site manager, whoever is there to represent the landlord. Give it to them in writing. Follow up with an email or a phone call. Or if you don't have like a written way of getting in touch with the landlord, I guess, you know, second best would be come with somebody, have a witness. So like bring a friend or like a family member. Let's say you're going to your residential manager's office on site to give the notice, so bring somebody with you. So if later on, again, if there is a dispute when the property manager or the landlord says, well, we never received your notice, so it's not just your word against their word, it's your word, and then you have a witness who says, yeah, I came on the 1st of October, and my friend gave the notice to the residential manager, or they slipped it under their door. And so then there are two people saying something that happened against one person who says, well, that did not happen. So that's more likely that you would be believed with your witness and not that one person. The landlord can end on a periodic tenancy. So again, if you're there just once a month, so there are more rules applying to the landlord. So they can't just tell you on the first day of the month that you have to leave at the end of this month, unless you previously agreed to that. Unless you have been a problematic tenant and you cause damage to the place, or other tenants are complaining about your noise. So if no such problems emerged, so then the landlord has to follow certain rules. So tenants can be evicted for a substantial breach. Substantial breach is non-payment of rent, causing damage, causing causing damage to the apartment or like to the building itself, like repeated complaints. Sometimes could be just like one complaint about something that you've done, like your noise is fairly common, or physical harm, or like serious aggressive threats towards other tenants. That would be considered a substantial breach. So the landlord has to give it to the tenant in writing, needs to explain why the tenant has been evicted. If it is rent amount outstanding, the notice has to say how much rent is due. And so the notice has to say who is to be evicted, who it is addressed to. There's one breach that can be remedied by the tenant. So if the cause of the eviction is only non-payment of rent because the tenant is late, so if within 14 days the tenant pays the rent, then that eviction notice can be ignored because that breach does not, so the reason for that eviction no longer exists. But for any other reason, the tenant cannot just, like if there were complaints against the tenant for noise, they can't just be quiet now and ignore the notice. They either have to leave within 14 days, or if they don't want to leave, they have to write a letter to the landlord to say that they are objecting to this eviction notice, and so then the landlord would decide what the landlord wants to do, if he wants to talk it out, work it out with the tenant, or the landlord can take the matter to the dispute resolution service to have an officer decide, and the landlord can apply, can request an eviction order. In some cases, where there is a significant damage to the property, like windows broken, or like a fire, or the water taps not attended to and there is a flood, or windows left open in the winter and then the heating pipes burst. So then in that case, the landlord can issue a notice of eviction just for 24 hours. And if the tenant does not leave within those 24 hours, so then the landlord can bring a court application to get an eviction order. The landlord would have to act fairly quickly in such a situation, because if the landlord does not act within 10 days, so then that notice to leave within 24 hours would be of no effect, because the landlord did not act truly as it were an emergency situation. There are other reasons where the other rules that the landlord has to follow, and other reasons when the landlord can end a periodic tenancy. So, like for example, if the tenant is employed by the landlord and they just live in the place on a month-to-month basis, so once the employment is down, the landlord can ask the tenant to leave. If the landlord wants to convert the building into a condominium property, so then they can also end this tenancy. The landlord wants to use the premises for something else, not for people living there, but maybe they want to have it as sort of like their secondary residence, or like storage space. Any such reasons could exist. If the landlord is selling the place and so they have a buyer, if the building is very old and it's easy, like it makes more sense economically for the landlord to just demolish the building and build a new property. So these are the reasons when the landlord can tell the tenant that I don't want to continue on a month-to-month basis anymore. And so for the landlord, the notice would have to be longer, like depending on what the reason is. So it's not just 30 days. It would be so if it is not like a substantial breach, if it is not a serious breach, so then it could be a couple of months, depending on the reason. So for example, if the landlord wants to sell the place or to convert it into a condominium, so they have to give the tenant 3 months notice. Basically, for you maybe to remember and understand more easily, just know this, that as a tenant, you have more flexibility. On a month-to-month tenancy, you only have to give them 1 month, but for the landlord, unless there is like a serious breach on your part, for landlord, the notice has to be longer. Again, like it would depend on the reasons why they terminate the tenancy, but it would be just a couple of months. Okay, so I have some information about human rights legislation and how it comes into play when we talk about the rights and obligation of tenants and landlords. So in Alberta, we have a Human Rights Act, again, a piece of law that prohibits denial of rent, renting a place on the basis of race, religious belief, color, gender, physical disability, mental disability, status, marital status, source of income. So I have those grounds. They're called grounds of discrimination. So they are highlighted on my slide. So for any of those reasons, the landlord cannot refuse to show the place, to rent the place, to refuse to extend the lease. If the landlord does that, then that is potentially a human rights violation. And a person who believes that they were denied renting a place or extending the lease on any of those grounds, they can make a complaint to the Alberta Human Rights Commission. Let's see if I have the address. So I have the slide at the end of my presentation where this information is included. So Alberta Human Rights Commission. So any of those protected grounds, like I said, race, religion, color, ethnicity, physical, mental disability. And this slide that we have in front of us right now provides some examples of prohibited discrimination. So because somebody is on a social assistance by itself is not enough to refuse to rent, because even though the person is not working, they do have a source of income. So it should not matter what that source of income is, unless it's like an illegal source of income, like somebody is doing doing drugs or selling off stolen property and the landlord knows about it, so then they can refuse, because then the tenant or prospective tenant would be doing something against the law. That's a violation of the tenant's obligation. So that source of income would be permissible to deny renting based on, but otherwise, no. Another common ground or another easy example of prohibited discrimination is if there is a family with many children. So then there would be discrimination on the basis of family status. If the landlord just thinks that, well, there's just too many people and they are going to be allowed. So that's not permitted for the landlord. They can refuse to rent a place to a very large family if the place is just too small as compared to the minimum housing standard. So remember how at the beginning of the presentation I told you that landlord has to comply with the minimum standards in terms of the health, like the levels of like water, moisture, like toxic substances, anything that creates a health hazard living there. So we also have a prohibition against overcrowding in those minimum standards. So, and that's written into the minimum housing standards. So if the landlord sees that, well, it is going to be a family of 5 wanting to live in a 1-bedroom apartment, then that's against the minimum standards because it's just a situation of overcrowding. So in that instance, they can refuse to rent. Some other examples are asking the source of prospective income. Again, unless the landlord knows that the income is from illegal means and illegal activities. The landlord is also prohibited from refusing to rent on the basis that the person is new to Canada, because they have no rental history, they have no nobody to give them a reference as a previous tenant. So this would be a discrimination on the basis of origin. Okay, now let's talk about some of the obligations on part of the landlord that are not performed properly and what the tenant can do in that situation. So the landlord has to maintain the appliances that they provide. So very common appliances are fridge, stove, microwave, dishwasher, and they're usually stated in the lease. If they are not, then please ask landlord to write in what is included. So then if those appliances break down, the landlord has to maintain them. They can ask you to contribute to the cost depending on what the reason for the breakdown is. If it is just like wear and tear, you know, if you moved into the place and the fridge was already there, the fridge was not brand new, it broke down in a couple of months, you did not do anything to the fridge, then it's not your responsibility to pay for the replacement. So the landlord has to do it, and they cannot charge you money for that. If you are living in a place where some appliances stop working, the landlord does not replace them. If conditions deteriorate and the landlord does not take steps to repair and bring them back to the level of just normal, proper levels of having those conditions in your home, you can ask for a rent abatement. A useful term to know, which means reduction of rent. And you would ask for a reduction of rent because you are not getting your full money worth, so to speak, from the place for which you first agreed to pay for. The amount of the reduction has to be reasonable. Sometimes, you know, if there is a dispute, you can make an application to the landlord tenant resolution service, and then you would let the official adjudicate how much money is reasonable to deduct. But before you go to that step, so try to offer a reasonable reduction for the landlord. Like I said, you know, there was, like I gave you a few examples. So, you know, if somebody moves in right now, then there's a problem with heating, then the temperatures keep dropping. It's not a dangerous condition to live in, but it's uncomfortable. So you could maybe ask for like a third or half of the amount to be reduced. If you move into a 3-bedroom place, let's say, and there was a flood, and one of the rooms, and the flood not because of your misdoing of any kind, one of the rooms is not usable, you cannot use that room. So then you could ask for a reduction of rent. Again, if it is like one of the 3 bedrooms, maybe a third, because you were not able to use that third room for, let's say, a month or a couple of months. You can contact Alberta Health Services. This is the government department that can conduct an investigation and can make an order and an assessment to determine whether your property is unsafe, sanitary, or in serious disrepair. And so then if you have that assessment, that report, then it would be easier for you to make a claim for rent reduction. And if the landlord disagrees, then you would have a higher chance of a higher likelihood of winning if you were to take your case to the court. Now let's talk about bed bug. That's kind of like an unpleasant topic, but it's a problem that can and does occur periodically in Edmonton. So from the outset, it is the landlord's responsibility to ensure that the premises are free of infestations, bed bugs, any other insects, mice, rats. If there is a problem with the bed bugs, so from the outset, the tenant has to notify the landlord. And it comes to all repairs, to all issues that you observe in the place. You first have to let the landlord know. If they don't know what the problem is, you cannot have a claim against them later on that it was not fixed. You have to notify them. And again, the notice should be in writing. And ideally, you should maybe like email the notice, or if you drop it in under the door of the property manager, just follow up by email or text message saying that the repairs need to be done. I stated them in my notice, and I delivered the notice to the property manager on whatever day. So then with the bed bugs, the landlord or any other infestations, the landlord, once they receive your notice, they have to pay for and arrange for an extermination. And so then you're obligated to cooperate them in, wash them in hot water, put them out in the balcony or just outside for some time, like vacuum clean your furniture, things like that. So you need to comply with that depending on what the instructions are. The landlords can charge the tenants for the cost of getting rid of the bed bugs if the landlord can prove that it was the tenant who brought in the bed bugs. Like if they saw you moving in and they bring, like mattresses into the place and they saw bed bugs crawling out of those mattresses. So then, that's a proof that it's not a pre-existing problem. That's the tenant who brought in the bed bugs. So in that situation, even though the landlord would have to take steps to exterminate the infestation, they can pass the cost on to the tenant. When complaining about the bed bugs or any other infestation, so photos are very good evidence. It's not just the bed bugs, it's just anything wrong with the place. Kind of, pictures, they say a picture is worth 1,000 words. So if you can take a good quality picture, like in good light condition, well focused, sharp, so then that might be better and clearer and more immediate as evidence of a problem than if you were trying just to explain in sentences and words like what happened there. So let's move on. So like I told you previously that you can involve Alberta Health Services, so it's government's health department when it concerns environmental health and the living conditions. So they can come out and they can inspect the place to see if it complies with the minimum housing standards, and that does not cost you anything. So I have the phone number on the slide, which you can call. You can also, let's see if I have the website address. No, I don't have the website address here, but you can even Google them. So I have the phone number, and even if you Google Alberta Health Services inspection, so then you would get to the web page where that inspection is described. You may be able to request it online now. I'm just not sure. The government slowly is making the move to provide services, to arrange for appointments and things like that, not by phone call, but through the online systems. But in the last couple of months, because of COVID, those systems may have been disrupted. But generally, with the government, you can trust that whatever information is on their website is current. So if it currently says that you have to call, then you have to call. Okay, so sometimes situations arise when the tenant cannot, where the tenant has to leave and they cannot get their property back. So the landlord should give the tenant a reasonable time to pack up and leave.
How should I solve this?
Excuse me, somebody, would you please mute your microphone? Somebody's talking about something that has no relation to our session now. So the tenant leaves and the property is left behind. So the landlord is not obligated to keep it if the property generally is less than $2,000, like, clothes left behind, pets and pens and pots. So if we're kind of looking at all of this together, it's going to be less than $2,000. If it is more than $2,000, 30 days you can sell it. If and the tenant comes back, the land within 30 days. Leave them in the place, so the cost of the storage would be the responsibility of the tenant. So now to pay. And if informal dispute resolution is not successful between the tenant and the landlord, then the landlord can make an application. The tenant also can make an application to the RTDRS if they cannot work out the dispute with the landlord. So they can make an application for the recovery of all or a portion of the damage deposit. If there are problems with the place and the landlord is just not making the repairs, so then the landlord is not keeping their obligations, so then the tenant can make an application to end the lease. Ends up paying themselves of somebody to dry out the place to get rid of like excessive moisture, mold, things like that. So if the tenant pays for that on their own and the landlord refuses to compensate them, so then the tenant can make an application for the compensation. As I said, rent abatement, again, very useful mechanism, very useful remedy for you to keep in mind. If you are not getting the full value of what you pay for in the lease, like if the place is still livable, but some things are missing in terms of basic health standards, comfort, use of all the space for which you are paying, so then the remedy is rent abatement, which also in plain language means rent reduction. So if there is a substantial breach by the landlord and there is a public health order in effect, and again, you can get this order by calling Alberta Health Services and getting an inspector to come out. An inspector would come out and do a report. So then you don't have to continue with the rest of the lease. You don't have to wait for 30 days. If you're on a fixed, on the periodic tenancy with a public health order, then you can leave as soon as possible, and you're not responsible for the remaining months on the rent under the agreement with the landlord, but you have to notify the landlord to say the reason why the tenancy is terminated, attach a copy of the public health order, and tell the landlord when you are going to move out. The landlord can object if they fix the issue within 7 days, whatever was in the public health order, setting out the problem. If the landlord would have a week to deal with that, and if they do deal with it, so then basically they can expect that you continue to live there and be bound by the terms of the tenancy. So options for resolution, as I said, so the third bullet, residential tenancy dispute resolution service, would be your second line of attack, so to speak, after you tried with the landlord or their agent, property manager, and they're not responding, or they're ignoring you, they disagree. Even if you just Google, these days Google search can be very user-friendly and give you good results very quickly. So you would Google Alberta residential tenancy dispute resolution service. You would get the information. In some cases, you would have to go to the provincial court or further to a higher level of court, Court of Queen's Bench. But again, the first you need to look at RTDRS. Situations help if you are looking, like for example, if you are looking for the compensation that is higher than $50,000 to do some really nice, make it a livable. RTDRS cannot give you more than $50,000 back. Like they won't give the money order that the landlord pays that money. Also, in a situation where, remember when I said before, it's very important to establish from the outset what kind of living arrangement it is. If you live with a landlord and you share any living accommodations together, so then you cannot go to the RTDRS, because then you are not covered by the Residential Tenancies Act, and your proper avenue is to resolve the dispute through the court. So that would be the provincial court. At RTDRS or at the provincial court, you can represent yourselves, or you can have anybody like a friend, a community member, anybody who you trust and who might have a better understanding of the situation longer, so they can represent you, and so their kind of legal role would be your agent. The landlords often agents responding to the claims brought by tenants. Like landlords often themselves don't want to involve a lawyer. So somebody who appears there on behalf of the landlord to participate in the dispute resolution, and they would be the agent. Except the highest level of the court, so there either you do it yourself or it has to be a lawyer. It cannot be a non-lawyer representing you. So lastly, I have a few resources to tell you about in terms of actual places, organizations, services where you can get legal help. So I work for the Edmonton Community Legal Center. The contact information is on the slide. We help with landlord-tenant issues and disputes. We don't charge at all, but we are an income-based eligibility service. So when asked how much your household income is, and household income means you and your spouse, if you have a spouse, and that would be assessed in comparison to your family size. Our intake workers have their own guidelines that they follow. So like a family of 2 would have whatever maximum income, a family of 5 would be their income. So depending on the information that you give them about your income situation, you will be determined eligible for our free service or not eligible. If you are eligible, and if you have a matter where like it's a truly legal issue, so then you'll be given an appointment with a lawyer, either a volunteer lawyer, or we also have staff lawyers. Right now, because of COVID, our default appointment method is phone, or we if you, in theory it is possible, but you would have to talk to our intake. And if you prefer a video appointment, you would need to tell them, and they will try to accommodate you with a lawyer who is quite proficient, or who is sufficiently proficient in that technology. If an appointment requires in-person attendance, so then you would be given an in-person appointment, like if there are documents that need to be signed, if there is an affidavit or a declaration to be sworn. So anything that cannot be done remotely, like by video or by phone, then an in-person appointment can be accommodated. But yeah, like I said, the default, sort of the easiest, the most common way for us these days to offer consultations is by phone. So to request an appointment with a lawyer to discuss your tenant landlord issue, call us at the number stated below or email. If you call, most likely you would be asked to leave a message, because our phone, we only have one line. We are quite busy with phone calls, and it is very often then when somebody calls, our intake is already speaking to somebody on the phone. So you would be led to our answering machine. Please do leave a message and indicate at what number you can be called back. Our intake does check voicemails very often, and phone calls are returned fairly timely and promptly. So just don't expect that you would always speak to somebody, and don't lose time to call multiple times until you speak to somebody because you don't want to leave a message. Trust like I would say that I know how our intake works, and our voice mail system can be trusted. If you leave a message, if you leave a callback number, you will be called. I think the target at this point is 48 hours to return the phone call. So then we also have Student Legal Services of Edmonton. So these are law students who already know enough about the law and the legal process to provide advice regarding landlord-tenant issues. Their phone number and their website is at the bottom of the slide. You would need to check the website or call them first to find out if they do phone appointments or video, or if they also do walk-ins now, that you can just drop by their office and get to speak to a student right away. It used to be possible. Now with COVID, many organizations, many businesses are like they had to adjust, and sometimes they change these protocols. So it's important to find out ahead of time how they can serve you in terms of like in what manner, in what format. Then we have information about Legal Aid Alberta. Their phone number is on the slide and the website. They don't specifically deal with landlord tenancy matters, but I guess the information is just on the slide for you to understand your other types of legal recourse, like family law, family and criminal. This is what Legal Aid mostly provides coverage for. Legal aid will not charge you right away, but they are not free. Like eventually, like if they take you to represent, if they take on to represent your case, they do expect you to pay back, but there is no rigid timeline. It's usually kind of the understanding is that you have to pay them back as soon as possible whenever you receive sufficient income that could stretch over months, that could stretch over years. So in that respect, legal aid is not free. But our service, Edmonton Community Legal Center, like I said, we have the income requirements, but if you meet them, our service is free. So you would not be expected to pay back for that consultation or for a series of consultations that you would have received from our lawyer. And so then I also want to tell you about the lawyer referral service. It's a service, it's a phone-based service. They also have an online system now as well. So if you have a problem relating landlords, tenants, or let's say your landlord lived in the same house with you. So then again, that's not going to be the main landlord-tenant law. That's going to be like a contract law, and you just want to ask like basic questions of a lawyer, where to start. So this service can match you up with up to 3 lawyers practicing in the area of law that suits your needs the best. And so the lawyers who sign up to participate in this service, they understand that they cannot charge the client for the first half hour. So if you call the service, they provide you, let's say, with names of 3 lawyers, you can expect that for the maximum 30 minutes, you can speak to this lawyer at no cost. And beyond that, it's up to the lawyer to determine how they want to deal with your matter further. So for example, they can say, I can only speak to you for half an hour, or they can say, we can discuss your matter for as long as needed, but like I'll let you know that at the 30-minute mark, that's going to be my paid time already, and my rate is going to be whatever it is, and then you decide if you want to continue and pay the lawyer or just cut it off at that first hour. And so, yeah, the phone number for this service is at the bottom of the slide. And so that brings me to the end of our session today, and it's pretty good time. It's 3:58 on my clock. So Anna, I am available for questions to stay a bit longer. So if you as a host, if you have the capacity to just stay longer and maintain the screen and everybody's attendance, so that if anybody has questions, they can raise them right now. So I'm just going to return to our main Zoom page, and I'll look at the chat box. And so, yeah, if anybody has questions, you can raise your hands digitally. You will see like a function on the menu, raise your hand, or you can just drop your question into a chat box. And I have opened the chat box window, and I'm just going to be watching it. Or you can also just unmute yourself at this point and just say, I have a question, and go ahead with your question. Well, maybe while we are waiting for questions to come in, maybe like Anna, from your experience, do you get a sense, like in the community, what are the most common issues or problems that people have with landlords?
I think you touched on those mostly on the beginning, and I know as you were explaining all those problems that you can have, we had a few questions then. I'm not exactly sure. So I think it'd be the best if anyone who's attending has their own questions.
Yeah, okay, well, while we are waiting for the questions, I'll just maybe kind of like recap. So like what you always need to keep in mind, and if you were kind of, to remember only these things from this presentation, so remember this. So first of all, try to get all the terms, all the agreements in writing. The amounts of money, the dates of move in, move out. If the landlord says, oh yeah, like something is not quite in a perfect stage, but I'm going to repair it, let's say within a couple of months, try to include that into the terms of the lease, or if it is not, follow up with the landlord by email or a text message, and to say that, we talked on such and such a day, and you said that this is going to be fixed in, let's say, 2 months. Then number 2, if there are problems with your place, you have to let the landlord know. And I'm just emphasizing this because I've seen clients in the past that would complain about the landlord, that they did not do anything, and then the problem got exacerbated, the condition of the property deteriorated even more. But then when we start kind of getting into the core, into the heart of the situation, it turns out that, well, they never notified the landlord in the first place. So again, you are there day in, day out, that's your home. So you have the best knowledge of what's wrong, what's bothering you. So let the landlord know, do it in writing. Whatever you provide to landlords in writing. If it is not like a phone, if it is not a text message, if it is not an email, always put a date and sign your notice. Always have a copy for yourself. So then I guess the third takeaway point would be, if there is an issue, a dispute, so, you know, before threatening with the court or before thinking, okay, I have to go to speak to a lawyer right now, talk to the landlord and try to work it out between you and the landlord, or whoever is the landlord's representative, to deal with you and your tenancy term. Tell them what your position is, tell them why you think it's a problem and why they should be responsible for it. Give them a reasonable, you know, what's reasonable would depend on circumstance. Let's say if you had to pay for the repairs yourself and you just expect a compensation, then there's no real urgency there. Yeah, like for you to receive a compensation. So give them like 2 weeks. But if it is something more serious that has to be dealt with, you know, like bed bugs, like no hot water in the place, no heat, the doors are kind of wobbly and you're afraid for your security, so then you should not be waiting for 2 weeks. Give them, let's say, 3 business days to fix the problem. And so then if that does not work, then you can bring an application to the Residential Tenancy Resolution Service.
I believe we have
Hello.
a question.
Yes, hi.
Hello.
Hello, I have a question. Is it legal the landlord asks you the income when you are looking for the rent, the income you made? Sometimes they ask you, oh, bring your income you make in return. So that's illegal, or they're supposed to be just asked, not asking you in return later how much you make a year or whatever?
So they can ask about, yeah, like they can ask about how much, like, you know, yeah, like they can ask about your income, but they cannot refuse of the source of income. So in like whatever your income could be. So long as it's legal income, let's say if it is not employment income, they cannot ask you, so they cannot refuse on the basis of the type of income, but they can ask you about the amount, because, you know, like as a landlord, you want to ensure that whoever you bring in can pay you, like can pay the rent.
But they can, yeah, but they can ask, but they don't need to improve. You don't need to show. What I'm making here, whatever, is illegal, or how much you make, or I make this one, that, and done.
Well, actually they can ask, so, and how they can ask, so they can ask for, like, for your employer, like information, so just to call them and verify that you're working. They can do it, but they like whatever they ask for has to be reasonable, you know, like, for example, if they say, oh, you know, we want, so let's say they say, I want you to see your bank statements, well, then you can receive as well, no, like, you know, like I can give you a reference information for my employer. I can give you a letter from my employer confirming that I have income. That's enough for you to know that I have income. You do not need to see my bank statements, you know, like for the last couple of months. You do not need to know how much I have in savings or whatever else.
Oh, okay.
They just need to be kind of, you know, to be satisfied that, like reasonably satisfied. Yeah, like if they want to know more, then like at some point, like the limit of reasonability stops. But you have money every month, like for the duration of the lease, $1,000 coming to pay the rent. If it is your have any reason to deny or so they don't have any reason to demand like a written confirmation of income. But let's say, you know, if somebody shows up and they want to rent a place for a year and they look maybe kind of disheveled and, you know, maybe their clothing looks like it has not been washed for, you know, like a couple of weeks, and they kind of, you know, they are late, they don't make a good impression as it like a trustworthy person, so then the landlord might just need that extra assurance that the person has the money to pay rent, so they can say, well, I would like to just a confirmation that you are employed,
Right.
that you can pay the rent.
Yeah, also I have seen it when you are looking for rent. Some of them, for example, you call them, hey, you do have a 3-bedroom, and instead they're answering you. Some of them, they really waste your time, how much you make money, and you know, all these details on the end. And some of them really, they just show you and they don't waste your time. They don't. Some of them, they really interview you before you even see the house, assuming you're gonna like their houses. And sometimes I wonder, is that really legal? Wasting somebody you call and say, hey, I'm looking rent, do you have 3-bedroom? But and they instead they answer your question, they really waste the time, how much you make, how many kids you have, how long you that. And I wonder, I don't know if it's just illegal.
Well, so some questions would be illegal, you know, like if they ask you, well, like, you know, I suppose, let's say if they ask you about how many children do you have, if you say, well, I have children, and they refuse you, like for a 3-bedroom apartment, that would be probably illegal, because there's no issue with overcrowding.
Yeah, no.
But let's say, you know, if you have like a large family, like there's going to be like a family of 7 or 8, you know, like by Canadian standards, that's overcrowding. And in many parts of the world, you know, like people live crammed into very tiny spaces, but in Canada, it would be considered overcrowding.
Yeah, we know that.
They can ask those screening questions, yeah, but like I guess, but then like if they say like they deny you because, well, that's, you know, too many children, we don't want that, or you're a newcomer, you don't have any rental history in Canada, so that would be illegal. But you know, generally, if they want to ask those questions before they show you the place, you can ask them, because you know, I guess it takes time to arrange for a showing. If the landlord lives in like a far away from the rental place, they have to go there. So if they believe, like if they see that, okay, well, you're not going to be a suitable tenant because, let's say, you look for a space that is going to be just too little in the violation of the standards, so then that would be appropriate. But again, like it would be like case specific, yeah. So let's say if they say, if they ask, well, so how much you look for a 3-bedroom place, how large is the family, and you say, well, the family of 4 for a 3-bedroom place, that's reasonable. If they say, well, actually no, we can't show you the place, then pretend like that's illegal, because they are denying on the basis that is improper. Like there's no issue with the overcrowding.
Yeah.
So that's illegal. But you know, what can you do about it? You know, like you can make a complaint against them with the Alberta Human Rights Commission, but you know, unfortunately, with those complaints, they take years to resolve, and you know, like ultimately, you know, like you would move on with your life by the end of it, right?
Oh, sure,
because you can't wait on the street a couple of years so that the landlord, you know, rents you or shows you the place. But they're not supposed to be doing that.
For sure. Yeah, no, most of them, they are good, real. They're just willing to show you, and that's it. That if you like it, you rent. If you don't like it, you move on. But some of them, they just like, let me see it, you know, before you interview me so much and wasting time, you know. If you ask me, okay, how many kids you have, and you really, it's okay, the place, but of course, everybody's not the same. You perceive some people.
Yeah, sometimes like if the landlords had really bad experiences with somebody, so they kind of they're cautious, and so they, before they go into like showing the place and maybe even renting it to you, they just want because situation, as they can deny to show you the place on the basis of your income, so long as it's legal way for you to earn the money.
Sure, sure. Thank you.
Yeah.
All right.
So I'm sorry, my face is appearing very bright on the screen because the sun is now coming out, and where I am right now, it's kind of hard for me to block the sun this time of the day. Okay, so I'm looking at the chat. I don't see any questions, so maybe like last chance for everybody to drop their questions. I'm just going to put my contact info slide again. Let me. So that if you did not catch it, then you would know how to find us. So again, it's Edmonton Community Legal Center. Yeah, so yeah, that's the slide. The phone number, the email address. So if you have a problem with the landlord and tenant type arrangement, contact us. If you call, do leave a message. Always say what your callback number is, and our intake will get back to you during the business hours. Like I said, their current target is 48 hours. Sometimes it's slightly more, sometimes it would be less, depending how busy they are. So on this note, I guess, Anna, I don't see any more questions in the chat box, so maybe we can wrap up. And if you have any sort of closing housekeeping items, any reminders or announcements for the audience to make, so then this could be a good time.
Yes, thank you. So if there's no questions, this concludes our workshop session for today. So on the behalf of the Somali Canadian Cultural Society of Edmonton, I'd like to thank Ms. Kuranicheva for sharing her knowledge and insights today. I know I learned a lot, and I hope everyone else did too. We'd also like to thank all the participants who came out today, and I hope that you were able to learn and gain support from this session. Please feel free to join us for more upcoming sessions in the coming weeks about a variety of different business, legal, and financial topics. So this